So, Bill, I've been fascinated by the OJ case for 30 years, and you lived it. While you were going through it, what was going through your mind as to whether or not this was a typical case, an atypical case? What type of resources you had to enlist from this office to tackle such a challenge?
Yes, Nathan. First of all, it was an extraordinarily special case, unlike anything I had participated in. I had tried high-profile cases before the Simpson case. Simpson, right out of the box, was off the charts in terms of media interest, public demand, the strain on our office's resources, and the intensity of the effort not only by LAPD, but that was called for by our office to respond. You might recall we had two preeminent law professors writing motions for the defense. We had Alan Dershowitz from the East Coast, we had Jerry Ullman from University of Santa Clara Law School, and they were preparing motions. In the very beginning, it was Marcia and myself, and no support team. Very quickly, we were simply overwhelmed time-wise, and the office responded. We had platoons of law clerks. We were able to enlist attorneys from elsewhere in the office. But all of that came with some cost to other operations. But the office and the administration was very supportive.
And what lessons now, 30 years later, as you reflect back on the case, do you take away from the OJ case on, and we can there's certain things that went right, but let's focus on what didn't go right. What didn't go right, and what can we learn from that?
Well, one thing was there were simply a number of extraordinary events. I have a maxim about high-profile cases, which is the higher the profile of the case, the more extraordinary the events that surround it. The public really doesn't know about the fact that we had to recuse a grand jury when we were initially seeking an indictment, that it took 11 weeks for Marcia Clark and I to select a jury, that the defense did not waive time. So we started trial within 60 days of the filing of the information in Superior Court. So we were on a mad dash from the very beginning. And these are things that the office can anticipate in terms of preparing for what inevitably will be the next big one. It's LA, like you say, it's Hollywood. We're going to have media. We're going to have, if a celebrity's involved, that's going to up the ante in terms of public interest. And we simply have to anticipate that this type of thing is going to happen, and the office has to respond.
You know, it's been said that everyone is entitled to the presumption of innocence in the start of every case, but that celebrities really get it. In other words, that the juries often come in and they think, well, if someone's been charged with a crime, you know, they must be guilty. But when celebrities are that defendant, they actually are accorded that presumption of innocence. Do you think that's true? Absolutely.
Yes, celebrityhood is an enormous dynamic that comes into play. Before the Simpson case, I had tried a minor celebrity named Todd Bridges. And basically, he shot up a drug dealer in a crack house in South Central. Johnny Cochran was the defense attorney. And the celebrity dynamics were very much at play in that case as well. So in a sense, I was prepared for what we were going to have with Simpson. However, Simpson was off the charts beyond what I could have even foreseen.
And Simpson was a mix of both celebrity and potentially racial dynamics. Because again, it was a high-profile African-American who was on trial at a time where there were certainly issues dealing with the police and the African-American community here in Los Angeles. How much do you think that played in the trial as well?
I think that was a very major dynamic in the case, and perhaps the most dynamic, powerful dynamic in the case. Right after the trial, I mean, within an hour or two of the verdicts coming in, sheriff's deputies who had been with the sequestered jury came to my office and were reporting that the jurors talking amongst themselves were saying that was payback for Rodney King. And if you recall, and as you recognized, a scant 2 years before we had the verdicts regarding the LAPD officers in Simi Valley. And in the black community, that was felt like an injustice occurred. So that dynamic was omnipresent in our case. You could feel it in the courtroom. Marcia and I felt it during the laborious jury selection. It was certainly at play.
Now, one of the decisions that was made was where to try this case. You know, should it be tried in Santa Monica? I think there may or may not have been the venue possibility in Santa Monica versus downtown. How do you think that decision, or how did that decision get made at the time? And would you think a different decision should be made today if you had to make that decision again?
Yeah, very good question, and there has been a misconception with regard to that because the case did occur within what was then the Santa Monica Judicial District. I was not privy to conversations about where the situs of the case should be. I was kind of airdropped into the case right before the prelim to assist Marcia getting through the prelim and ended up staying aboard. But from what I understand in hindsight, one is that case inevitably would have ended up downtown. Why? It was a long cause case. At the time in Los Angeles County, every long cause case, that is a case which was estimated to be 3 weeks or longer, was coming downtown to the 9th floor in the criminal courts building, the long cause floor. Why? Those big cases were clogging up courts, not only downtown, but in the branches, and they could be moved through the system quicker in courtrooms that had more time to devote. So from what I'm told, that case would have come downtown regardless. Secondly, I learned some years later that the supervising judge in Santa Monica had asked the presiding judge downtown if the case could be down here because the Santa Monica courthouse was in essence a broken courthouse due to the Northridge earthquake, which occurred earlier in 1994. And there were security issues and simply the logistical ability to properly handle the case apparently was felt it couldn't be done there.
Interesting.
But last question you asked?
Sure.
Of course, if that case were to occur today, I think it should be tried in the judicial district in which it occurred.
And then let's talk for a moment about cameras in the courtroom. Because probably before OJ, and probably the Menendez case as well, which were kind of tried roughly around the same time, the public didn't get to really see what happened in a courtroom. In fact, they generally would get reports by reporters who were there. They'd read it in the newspapers the next day because social media didn't exist. There's no tweeting back then. They might see it on the nightly news with some reporter reporting live from the courthouse. But it was always interpreted through someone else. But all of a sudden with OJ, you actually were in the courtroom. You could watch it yourself and see how evidence was playing out in real time. What impact do you think that played in the case itself? And do you think in hindsight the DA's office should have pushed even much more strongly against having cameras in the courtroom for that particular case?
Yeah, as a general response, I am not a proponent of having gavel-to-gavel coverage in the courtroom. I appreciate the public's right to know, but in my experience, and I've been through a few of these cases, is cameras in the courtroom, gavel-to-gavel, are great for ratings, bad for justice. Why? Everyone acts differently in the courtroom, and the participants, from the judge to the attorneys, witnesses are well aware of the camera. Certainly, defense counsel in the Simpson case knew that they had an additional audience which was observing through the remote camera mounted on the side wall of the courtroom, and they played to that. And again, given the racial tension which existed with regard to that case, it just amplified the dynamics at play. If I were to recommend, I would say opening statements, closing arguments, verdicts, absolutely. those should be televised. But cameras in the courtroom day to day presents a different dynamic, which doesn't always help justice.
And that's interesting because an opening statement, a closing statement, they're actually not evidence. In fact, that's the jury instruction that the jury gets, is that what you're about to hear is not evidence. They're talking about evidence, but it's not evidence itself. So if I understand you correctly, the sort of almost non-evidentiary parts of a trial, but important ones, oral opening statement, closing statements, verdicts, would be or are proper for television and being televised, but the actual evidence, in order not to corrupt it, not to affect it, would be better left off the TV screen.
That's this reporter's opinion, yes.
When you go back and you look at the way and almost the timing of the presentation, it was not lost on me that there were actually two Simpson trials. There was the criminal one, and then there was the civil one. The criminal one lasted a long time. Daniel Petruccelli, in the civil case, managed to streamline that case in a fraction of the time and got a civil verdict granted under a different standard of evidence with different lawyers in the courtroom. That was the opposite in some ways of the criminal verdict. It was a civil verdict against O.J. Simpson, whereas the criminal verdict obviously was not guilty in favor of O.J. Simpson. Do you think that the length of the trial itself played against the prosecution in the criminal case?
It did, Nathan, and there were a number of factors which were beyond our ability to control. For instance, this case was really part of the advent of the application or the forensic application of DNA in the courtroom. So there was a sense that the jury certainly had to be educated about DNA evidence. And I do recall that there were people kind of chirping at us like, this is an opportunity to educate the nation. Again, this is a secondary purpose, so to speak, which was prompted by the cameras in the courtroom. But the phase of the case which took the longest to process in the courtroom was the evidence collection and the DNA evidence. Took well over a month just on that alone. The witness who was on the witness stand the longest was not a homicide detective, was not a civilian witness. It was Dennis Fung, the primary criminalist from LAPD, at 9 days on the stand. So I can tell you criminalists across the country took note of that and adjusted in light of what they saw Mr. Fung going through.
Yes, no, I mean, I don't ever recall as a prosecutor putting a criminalist on for, well, more than a day. Usually they get on, they get off, they establish the limited amount of information they need to convey to a jury, then you move on to the next witness. So, and I assume that was part of, in some ways, a defense strategy. Having been a defense lawyer myself, drawing things out, delaying them, sort of diluting the evidence in some ways, has always been a defense strategy. It sounds like that was carried out in the O.J. case as well.
I agree. I thought Barry Scheck in particular was excellent at cross-examination in trying to punch holes in the testimony of the criminalist, in the evidence collection and preservation procedures. It was very adroitly done. And I think that helped erode confidence in the people's case to some degree. Ultimately, the blood evidence was the blood evidence. The DNA results were the DNA results. The blood told the tale. And that tale should have concluded with O.J. Simpson being found guilty.
But then you had this Mark Fuhrman issue. Comes out pretty much in the middle of a trial. If I recall, they somehow were able to get transcripts from a East Coast case that they were able to dig up literally in the middle of the trial to further cross-examine Mr. Fuhrman on stuff he had said. Is there a lesson to be learned on the ability to investigate your own witnesses and thoroughly understand all the potential pitfalls that those witnesses might have. Is that one of the additional lessons that we can learn from the O.J. case?
Absolutely. And I'll tell you why. With regard to Mr. Fuhrman, I interviewed him several times, and my impression of him, he was a good, smart detective. I was impressed with his work on this case. Talking with others, they felt similarly. Shortly after the prelim, an author wrote a piece, I think it was in New Yorker magazine, and he, the reporter that is, had been given information about how Fuhrman had tried to get a stress disability off LAPD some years before, which was true. Someone leaked this information to the reporter. Like everything with the Simpson case, it was magnified in the press, and in connection with that effort to stress off from LAPD, Fuhrman used street language, derogatory terms for Hispanic gang members as well as black gang members, and that's a matter of record. So we dealt with that. We knew that going into trial. The turning point was when F. Lee Bailey asked the question in court, Mr. Fuhrman, are you saying that not once in the past 10 years have you used the epithet N-word? Is that your testimony, Mr. Fuhrman? And Fuhrman responded, that's correct, absolutely. Nathan, I'll tell you, my stomach turned over at that point. Not because I knew he had ever used that word. I just thought, how can you be absolutely sure you haven't read a police report out loud where one witness says to another in a gang shooting using that word? How can you say that? And very late in the trial, during the defense case, we had, in summary, a screenwriter come forward who Mark Fuhrman had talked to outside any criminal proceeding, and he kind of was the writer's technical advisor, and he used a combination of braggadocio, street language, in an effort to impress the female screenwriter. And that screenwriter, in the defense case, tried to market that here in Los Angeles for a lot of money. We became aware of it, the defense became aware of it, we subpoenaed the witness, got the information, and in truth, about 9 years and 10 months prior to his testimony earlier in court, he was on the record, tape recorded, using the N-word. That was, when I talk about extraordinary things happening in high-profile cases, that was certainly one for the books.
And if I might ask, were you actually in the courtroom when the verdict was read? And on a scale from 1 to 10, 10 being guilty, 1 being not guilty, what was your anticipation before the verdict was read as to which way it was going to come out? Your sort of level of expectation. On a 1 is not guilty, 10 is guilty. Where do you think you were before the verdict was going to come out?
Boy, under a 5. The afternoon before, we had readback in the case, and the readback was from the limousine driver who transported Simpson from his home to LAX to catch a red-eye flight to Chicago to play golf. And that witness was important because the murders occurred really about an hour and a half before the limo driver was at Simpson's house. That civilian witness, a young man, I thought was one of the most credible witnesses in the entire case. And the fact that the jury requested readback of the limousine driver gave me some hope. I actually kind of elevated my hope for it. But I can tell you, within 2 hours of that readback, they signaled that they had verdicts. And I know from speaking with the court clerk, they really didn't deliberate. They pretty much had their minds made up. I don't know where the limo driver played in. I will confess to you that as a manager in the office and the head of the Simpson prosecution team, I did think about a 2-trial strategy. much like the Menendez case, that I was already plotting how we could streamline things, as you've suggested, in the event there was a hung jury. But we never got that shot.
And if you had gotten that shot, since you gave some thought at the time to it, what would you have done differently in the second trial, if there had been a second trial?
Well, first of all, we would have been aware of all the surprise issues that came up in the case, including Fuhrman. We would have found a way to work around Fuhrman, or at least treat him as a critical witness. He found the bloody glove. There was some impeachment evidence with regard to one of the robbery homicide detectives that came in rebuttal. Another surprise in the case, which I, as kind of the captain of the ship, had to investigate while we're still in the defense case, flesh out an inconsistency in this one detective's testimony, get it documented, and I handed it over to the defense as part of my ethical obligation under Brady, and that was part of a rebuttal in the case. That was a surprise. Obviously, any surprise that occurred in the primary case, we would have remedied in the second case. As you've suggested, the presentation of DNA evidence, we would have compressed that much, much more. I anticipated the possibility of a new trial team. That trial took a toll on all the participants, a heavy toll, and I wasn't sure anyone would want to go through that again.
Including yourself?
No, I would have answered the call. I'm a deputy DA, so and I'll tell you, I mean, in all of this, as we approach the anniversary of the verdicts, that case is still like a wound for me. Yes, the wound is has been scarred over for a long time, but even preparing to come downtown today to meet with you and talk with some others, it took me back into that feeling, that frame of mind when the verdicts came in the case. And my bottom line feeling was we didn't bring justice home for the Goldman family, for the Brown family. And, don't care about the politics, the media aside. I wish we had brought it home for the victims' families.
Thank you very much.
Okay. See, I get emotional just thinking about it after all these years.